Hey, good afternoon, everybody. Thanks for joining my session. I'm Pat Forte, and my session is titled Understanding Ontario's New Long-Term Illness Leave, What Employers Need to Know. Move on to the next slide. I practice in Miller Thomson's Waterloo office. I have a degree in psychology and, of course, a law degree. I also have my Canadian risk management designation, and all of those designations come in handy in my day-to-day work. I've been in Waterloo Region for my entire career, and I think my claim to fame to this day is that I became a partner of the firm in 2007, which is the same year I finished paying off my student loans. I actually have two primary areas of focus in my litigation and advisory practice. First, of course, is employment law, which, among other things, includes advising about absence management and human rights. And second, insurance law, including in the disability space and providing advisory services about coverage and claims opinions, litigation about LTD claims on the defense or insurance side, plan design, drafting, interpretation of plans and policies, and the like. So leaves of absence and absence management is where my practice intersects. Understanding medical stuff and legal stuff in an absence management context, and what an employer's legal obligation or obligations are, is where my skill set perhaps peaks. Managing employee absences may be the bane of your existence, but it's a space that I'm comfortable with and routinely advise on. But let's move on to the topic at hand. And we can move forward from that too. I did have darker colored hair before the pandemic, by the way. Uh, we are gathered here today to explore Ontario's relatively new long-term disability illness leave. It's found in section 49.8 of the Act. And when I refer to the Act or the ESA, I'm referring very specifically to the Ontario legislation. The leave itself is part of a bill, Bill 229, which was creatively titled Working for Workers 6 Act. It's that bill that further updated the Ontario Employment Standards Act to enhance various employee protections and support. And parenthetically, the Working for Workers 7 Act was introduced this past May, and so be prepared for more changes. I checked the status of that bill this morning, and it hasn't moved past the first reading. A little bit of breathing room there. But let's move on by putting this new leave in some context. There are many statutory leaves under the Ontario legislation, and without counting, guess how many there are? Quick, just say a number out loud in the comfort of your own space. Uh, with the new long-term illness leave, but excluding a pending placement of child leave, there are 16 statutory leaves under Ontario's legislation. Importantly, this leave shouldn't be confused with the 3-day sick leave under the Employment Standards Act or medical leaves that employees are allowed to take as a form of accommodation under human rights legislation, or even, frankly, under workplace safety and insurance legislation. Those are separate entitlements, and I will speak about them later. But let's continue. Let's discuss some of the straight mechanics of the long-term illness leave, and then we'll get into the nuances. Before I do that, I want to put the leave in context to understand how it came to be. And for some, the leave admittedly may seem superfluous because of the existing protections for employees. So as mentioned, this bill stems from this bill 229 passed by the Ontario government back in December of 2024. It's the same bill that introduced the child placement leave and some stricter job posting rules, among other things. The long-term illness leave, though, actually came into force in Ontario this past June 19th. And that is to say, even though the legislation was passed in December of 2024, the leave became a formal part of the Employment Standards Act in June 19th. I actually went back and I reviewed the legislative debate about this part of the bill, and I have two things maybe to highlight. First, the long-term illness leave was enacted in part to rebut a perceived stigma of having for employees having to take time off when dealing with a serious medical condition. The government's pitch was people should be able to focus on their health when they're ill and not worry about their jobs. And the second highlight was just the duration of the leave, which is 27 weeks, not pulled out from the air. It was intentionally chosen to align with the length of the current 26-week federal employment insurance or EI sick benefit leave, including a 1-week EI waiting period. I should point out there was an NDP minister who noted during the debate that the bill actually didn't go far enough. You know, beyond enacting a 27-week job protected leave, what's missing from the bill are employer paid sick days. You might recall that paid leave was floated around for a while, but that didn't make the cut. So to be clear, this is not a paid leave that we're talking about. Let's move on and we'll discuss, what exactly is this leave? The high-level message is that under this leave, employees who can't perform the duties of their position because of a serious medical condition, air quotes, will now have job security under the Employment Standards Act. Again, that job protection arguably already existed under human rights legislation, albeit and admittedly, it's not specifically codified under the human rights legislation. So eligible employees, that is those who have at least 13 weeks, it's 3 months, of continuous service, can take up to 27 weeks of unpaid job protected leave within a 52-week span if they have a serious medical condition. So again, to be clear, no obligation to pay for this leave. That said, an employer can pay for the leave if they want, or if there's our existing policies to pay for some sick days, or if you have a self-insured short-term disability plan or something like that. But there's no legislated legal obligation to pay for this leave. I should point out, there is no definition in the Act about what a serious medical condition is. The only thing we know about it is that it can be, the medical condition that is, it can be chronic or episodic, and that the condition has to prevent the employee from performing the duties of the employee's position. So let's dig into that and explore that for a sec. Now, the word chronic is not defined in the Act either, but the dictionary defines the word chronic, or actually a slide ahead, we can go back if you want, but that's okay. The dictionary defines the word chronic in the context of a medical condition as a condition that's persistent, long-lasting, and generally expected to continue indefinitely or to occur over time. And to my mind, examples of that could include conditions like diabetes, multiple sclerosis, Crohn's disease, chronic depression. Those kinds of conditions require ongoing medical attention and can limit a person's ability to work continuously. Now, the word episodic is also not defined in the legislation, but again, look at the dictionary, and that word episodic in the context of a medical condition is a condition that comes and goes with periods of wellness followed by episodes of flare-up. The employee may be well enough to work for stretches at a time, but then becomes temporarily incapacitated during their flare-up episodes. And examples of some conditions that might be episodic in nature could include epilepsy or migraines, bipolar disorder, or maybe even autoimmune conditions like lupus. So even though the condition isn't constantly disabling, the recurrence of the symptoms still qualify as a serious medical condition. So this means that there's a recognition that serious medical conditions aren't always constant, they're not always immediately visible. The inclusion of chronic and episodic conditions means that employees with non-continuous but serious illnesses can still access up to 27 weeks of job protected leave each. Well, it's not even each year, literally speaking, each 52-week period. I'll tell you more about that in a sec. So what else do you need to know? An employer can ask the employee to provide written confirmation of the entitlement to the leave from a qualified health practitioner. I'm happy to tell you that there is a definition for who is a qualified health practitioner, and that term is defined in the legislation to mean a person who's qualified to practice as a physician, a nurse, a registered nurse or a psychologist under the laws of the jurisdiction where the treatment is being provided to the employee. Or it could be a qualified health practitioner that is listed in a regulation. And the language that's used in the legislation is a prescribed class of health practitioner. I can tell you that there's no prescribed class of health practitioner that is in the legislation now, but there could be in the future. So let's move on about duration. Just make sure our slides are synced. Great. So as mentioned, the leave can last for up to 27 weeks. The 27 weeks need not be in a row. Just because 27 weeks is available doesn't mean that's how long the employee gets. If the leave sanctioned by the qualified health practitioner is for 3 weeks, that's how long the leave is. If there's a recurrence, the employee gets to go back on the leave. In other words, if an employee returns and has another episode, they can within 52 weeks, they can go back and use up a remaining entitlement or extend their leave with a new certificate. If an employee, let's say, is away for 10 and a half weeks, an employer can deem partial weeks as a full week. So in effect, that 10 and a half week leave is really an 11-week leave for tracking purposes. And this is because the word week, of all words, is defined in the Act to mean a 7-day period starting on Sunday and ending on Saturday. So, I mean, technically speaking, I suppose we can say that if an employee is away on starting on a Tuesday, let's say, they are effectively away starting the previous Sunday. I'm not making this up, but I might be delivering it in a dramatic way. The leave isn't a one and done. Everything resets after 52 weeks. The employee is eligible for another long-term illness leave after the first 52-week period. It's also very, very important to note that 52 weeks is not the calendar year. It's not January to December. Here's the key point. You need, as employers, to track the leave and to have really good tracking mechanisms. I think now is an opportune time for us collectively to develop a tool, whether it's an Excel-based tool or something else, and to market it to other employers to help them track this kind of a leave. Let's move on and we'll look at what the employee requirements are for this leave. Primarily, employees have to give written notice that they'll be taking this leave either before their leave, which is a little curious, or as soon as possible after the leave begins. So if the leave is supported by a qualified, excuse me, the leave is supported, of course, we mentioned this, if the qualified health practitioner confirms that the employee has a serious medical condition that prohibits the employee from performing the duties of their job. As an employer, you have to actually ask for the certificate. The employee can request the time off and do nothing more. If you want the certificate, you have to ask for it. Again, the employee doesn't have to provide it automatically, but it does have to be, the certificate does have to be provided upon request. Remember, you're not allowed in Ontario to ask for a doctor's note for the 3-day sick leave. I don't want you to conflate the two. The certificate needs to confirm, again, the employee has a serious medical condition. And I would suggest using those words, that you would want a certificate for the doctor to say, so I am treating so-and-so, they have a serious medical condition. The certificate also has to note the estimated duration of the absence that's specified in the legislation. The certificate does not need to tell you what the serious medical condition is. Let's dig in here a little bit more though. Remember, serious medical condition is not defined other than to say that it can be related to a chronic or episodic condition. And we've already discussed what chronic and episodic conditions might include. The other consideration, though, is that the condition has to prevent the employee from performing the duties of their position. And this suggests to me that the condition would have to cause the employee to have a physical or a psychological or a cognitive limitation or restriction or multiple restrictions or limitations that impair their ability to perform the duties of their job. And for me, my belief is that the medical certificate that you receive from the qualified medical practitioner should also reference that the employee suffers from a serious medical condition that restricts the employee from performing the duties of their position, or something to that effect. You know, the basic note that states employee cannot work for medical reasons, I would say would not suffice for, this hasn't been tested, this is a new leave, but reading the act, I would say wouldn't be sufficient to qualify for the long-term illness leave. If you receive that kind of a note, um, my recommendation is to make inquiries if the employee intends to take the long-term illness leave, and if so, to request the requisite certificate with the required information, which again includes the approximate time or duration of the leave. I want to also briefly segue here, now that it has come into my mind, about disability plans. For employers who have short-term disability plans available, either because you're self-insured through the company or with an insurer, your employee can still access that plan depending on or according to its terms, of course. Under disability plans, the word disability or total disability is typically defined, or it is defined by the terms of the contract. And the definitions vary, but they're usually linked to an individual's incapacity or inability to perform essential duties of their own occupation. And it's typically tied to a requirement by an employee to be seeking some treatment for their condition and other contractual criteria. If an employee does not qualify for short-term disability or any other income replacement benefit, they're still eligible for this leave, right? The criteria under the Act is standalone. The legislative entitlement to a long-term illness leave and the contractual entitlement to a short-term disability benefit is different. Again, an employee who meets the criteria for the LTI under the ESA is unconditionally entitled to the unpaid leave, regardless of whether they qualify for paid disability benefits. And in the same vein, the employee can be on the long-term illness leave and be paid through a disability plan concurrently. In my view, these leaves don't stack. So let's take a look at the employer requirements next. So employers are required to hold an employee's position and then reinstate an employee when they're clear to return. If the leave is extended, an employer can ask for a further certificate to support the extension and to confirm the employee still has a serious medical condition that prevents them from performing their duties. Employers can request other requisite information to support that the leave criteria is met. And as mentioned, you need to have really good tracking mechanism in place to confirm and ensure compliance within that 27-week period. If an employee takes only 20 weeks of a leave in a 52-week period, that extra 7 weeks doesn't get carried over to the next 52-week period. And let's look at some other variations of this. If the medical certificate says that the leave will last 18 months, like that's about 77 weeks, the employee gets 27 weeks of job protection under the ESA for 52 weeks, and then the leave entitlement technically resets after that 52-week period is over, and the employee gets up to another 27 weeks after the initial 52-week period is over. But at the end of the day, the leaves over 27 weeks are still protected under human rights legislation, potentially under workplace safety and insurance legislation. The job status protection under the Act may notionally drop off after 27 weeks under the Employment Standards Act, but the human rights obligation remains. And we'll talk about the human rights overlay in a bit. In effect, employees who are eligible and who qualify can't be denied the LTI leave. It's a legal leave, yeah. Employees are kind of bubble wrapped in this protection. And, hey, I get it. I field calls all the time, and a leave of this nature that can, stop and start is disruptive to a lot of workplaces, especially if an employee occupies a mission critical kind of a role. However, It is illegal to fire an employee who takes a statutory leave like this just because they've been on a leave. Talk about that a little bit more. There are some other rules that you need to keep in mind. So let's move on to these. So outside of the we can just move on to the next slide. Outside of the provision about the long-term illness leave, you have to actually jump over to section 50, 51 actually to start. There's another part of the ESA that applies to all statutory leaves, including pregnancy leaves, parental leaves, organ donor leaves, and the like. These sections also apply to the long-term illness leave. So the first one, Section 51, it's that section that says, hey, when somebody's on a statutory leave, you have to continue their membership under all the benefit plans, a pension plan, et cetera. Keep that in mind. If employees co-pay your benefits, an employee who's on a leave still must continue that co-pay. Now they're not getting paid, so how do you deduct their contribution? You actually have to let them know. I listened to the back end of Jill Wilkie and Claudia Desjardins' presentation, and they discussed, having a program or templates in place to manage leaves of absence. I think that's really great advice so that issues like this can be addressed. Hey, employee, you're going on this leave of absence. You co-pay the extended health or life benefit. What would you like to do during your absence? You would still, if you want your coverage continued, you have to provide us with the premium payments, failing which your coverage can be suspended during your leave, which is permissible. You also have to discuss maybe some time off. Don't forget, under Section 51.1, employees who are on a leave of absence still accrue statutory vacation time off. In Ontario, that's 2 weeks for first 5 years of employment and 3 weeks afterwards. So it's really important to not conflate the concept of vacation time and the accrual of time off compared with the accrual of vacation pay, and that will fund the vacation time off. An employee who is on a leave of absence who is not receiving wages does not accrue vacation pay. So after a leave, you have to be mindful that an employee may have stocked away or accumulated some time off, but not the vacation pay. And the result is that they're entitled to unpaid vacation time off. Remember that. Let's move on to section 52, which is in the next slide. Don't forget that the Employment Standards Act also mandates that an employee's leave or the period while they're on the leave is also included in calculating their length of employment or length of service and their seniority. So inactive service counts towards the duration of their employment. And that's important, at least in Ontario, in 3 main respects off the top of my head that I can think of. Well, maybe 4. One, your vacation entitlement, right? It's predicated on your years of service under the Employment Standards Act. Number 2, your termination entitlement under the Employment Standards Act is contingent on years of service, as is severance pay. And the fourth thing that tenure of service is important for employment standards purposes is confirming your eligibility for certain things, like certain leaves of absence. The Act specifically says, though, that a period that of an employee's leave is not included in determining whether they have completed a probation period under an employment contract. So let's move on to section 53, which I think is the most important section when it comes to leave, to keep this in mind. And I've already alluded to this so far. An employer has to reinstate the employee who's on a statutory leave to the position the employee most recently held with the employer, if the position still exists, or to a comparable position if it does not. The obligation to reinstate doesn't apply if the employee or if employment is ended solely for reasons unrelated to the leave, like a legitimate restructuring, downsizing. This employee was not singled out to be the odd person out, and they lost their employment. Having a new employee take over the role occupied by the employee on the leave does not mean the position is not available. for the employee to return to. The employee on the leave in this regard would have, to use union phraseology, maybe it has that bumping right. Their position is still there and their right to be reinstated. The right, the reinstated employee also has the right to be reinstated at a rate of pay that is equal to or the greater of the rate they earned. So they can't be penalized and their salary rolled back because they were on a leave. But they're also entitled to receive a benefit. During their absence, if they would have received a pay increase, let's say cost of living increase, that has to be applied to them. They can't be penalized just because they're away. And think of it also in terms of outside the LTI concept. Like think about women who take pregnancy and then parental leaves. It's a way of confirming pay equity to mandate these auto pay adjustments and increases for people who on employees who are on statutory leaves. Let's move on and consider now how this leave interacts with other legislation, right? So we're going to be talking about maybe the ESA itself, human rights legislation, and to a certain extent the workers' comp laws. First, let me mention employment insurance. We already discussed that this leave was designed to kind of fit hand in glove with the EI sick benefits that are available. It was only a few years ago that the federal government increased the eligibility, not eligibility, the entitlement, the period of entitlement for sick leave benefits from I think it was 17 weeks to now 26 weeks. That's about 6 months. Employees have to qualify separately for that EI benefit. As an employer, you have to issue your record of employment within 5 days of that interruption of earnings. You would use code D as in dog, which means illness. That's the reason for issuing the record of employment. Um, Another, piece of legislation where this leave could intersect with is that I mentioned it before, that 3-day sick leave under the Ontario legislation. Remember, you can't ask for a medical note for that leave, but you can ask for other corroborating information, including a declaration from an employee for that kind of a leave. Where the employee would sign, I declare that I was really sick for those 3 days. Whether you're going to do it or not is up to you. But this leave does stack with the long-term illness leave. So don't count this 3 days with your 27 weeks. Let's talk about the human rights legislation. So employees who take a long-term illness leave under the Employment Standards Act can obviously continue to be ill or unable to work after 27 weeks. They can't return to work. They're still entitled to carry on with their leave under the human rights legislation. An employee who has a disability and who can't perform the essential duties of their position, can be fired under the human rights legislation, but before an employer can do that, the employer has to go through its duty to accommodate to the point of undue hardship. So to be clear, that was a little bit of a word salad on my part. An employer cannot discriminate against an employee by firing them because of an illness or disability unless the employer first examines and undertakes its procedural and substantive duty of accommodation to try to help the employee perform those essential duties of the job. And in that process, ideally, there would be accommodations put in place that would enable the employee to perform those duties. Um, uh, the the LTI leave and the leaves under the Human Rights Code are effectively the same leave, but they're two sides of the same coin is maybe the best way to describe it. And to my mind, they're kind of concurrent. One major difference is that there's no time limit to the leave under the Human Rights Code either. And the obligations, certain obligations aren't as codified under the Human Rights Code as they are in the Employment Standards Act. Think of these leaves as being, leaves on parallel paths. An employee who's on an Employment Standards Act leave is also contemporaneously on a leave protected under human rights legislation. If an employee, though, doesn't qualify for whatever reason or runs out of that runway, that 27 weeks in the ESA, they're still eligible and qualify for an ongoing leave in the human rights regime. So let's start wrapping up by putting some pieces together. We'll move on and just kind of give you my thoughts about best practices and implementation. Um, review and update your policies, your workplace policies. Ideally, you would align your company documents with these changes. If you have templates, absence management templates, align them with this new leave if you're in Ontario. Ensure that the leave policies explicitly outline the eligibility and the documentation process for this specific leave. It's a little nuanced. You're also perhaps going to want to align this long-term illness leave with the more general or broader leave under the human rights legislation. Importantly, because of the tracking that's involved and because of the potential intermittent nature of an employee's serious medical condition, tracking the leave is going to be imperative. So I don't know of a admittedly of a product that specifically would track. I suppose there are spreadsheets and the like, but be very mindful of the tracking obligation and the rules around entitlement and eligibility. 27 weeks and 52 weeks being important among them. um, you know, Build some workflows and templates around the notice of the leave, requests for certificates, checklist for what the certificate needs to say, and maybe some return to work. I'm a fan of those standardized forms if you can have them. Of course, like something like accommodation is always an individualized situation, on the back end of a leave when somebody's coming back. And you want to ensure privacy and handle health information sensitively and all of that kind of stuff. But we'll go on to just some higher level risk management thoughts. Um, I, I think it's really important to train your managers and other people who are dealing with the leaves on the front end about this leave and about proper inquiries and return to work procedures and documentation. The nature of this leave might also cause you to build in like redundancies in your workplace. It might prompt you to diversify some training in the workplace so that, if somebody's down in this, on a leave that and they're coming and going because of this permissible leave, you'll at least have backup maybe by some cross training or through some cross training of other personnel. Communicating changes, being proactive with your team, with your managers and employees can also reduce some confusion about the leave. And don't get me wrong, I think confusion might happen anyway because of the overlap with other leaves that we've discussed. So I built in some time for some questions. So we'll move on to my last slide. I want you all to know that, and I want you to consider, am I the only one who finished on time? And if I am, I I want you to tell me because I think I get a prize. I'm not sure, but I think I should, and I want to be able to leverage that with my colleagues. So I have a question that I'm going to answer uh, for you first, and then I'll look to if there are any other questions that we have. But one question is, my employee has gone on a leave of absence and provided a doctor's note stating uh, that the leave is from, so the medical note states that they're going to please excuse the employee from September 9 to October 30th for medical reasons. Should we assume the employee is on an LTI leave, long-term illness leave? If we were live in person and if you had your audio on, I would create chaos and I would ask you all to answer the question. What do you think? Let's do this Socratically. Um, but we're not in that setting. And so I'll just tell you what I think. No, I don't think a note that says, please excuse employee for medical reasons, for this period of time, because I don't think it meets the requisite criteria for long-term illness leave that we just talked about. It doesn't refer to the employee having a serious medical condition. There is the requisite time period of the duration of the leave, so that's fine. So I think a note like that would prompt discussion with the employee. Uh, you know, engage your employee in discussion. Ask, is it your intention to take this long-term illness leave? And you explain what that is. And then you can request the certificate, right? You want to make sure that it's being provided from a qualified health practitioner and that it meets the other criteria that the legislation provides. So if there are no further questions at this point, I think I'm in a position to maybe give you about 5 minutes of your time and your lives uh, uh, back, because this would technically conclude my presentation and today's virtual conference. And I guess on behalf of my colleagues in the firm, I hope that your experience with us was insightful. Um, uh, for those of you who uh, are looking for CPD credit, don't forget about that. Our session is accredited, and don't forget to register your continuing education credits after today's session. Thanks for spending time with us. We're here to help. My motto is call us sooner. I think if we can get in front of situations before they happen, a lot of good things that will can happen. My understanding, before I totally finish, is that a copy of unanswered audience questions will be provided, and things like survey questions, recordings, and presentation materials are going to be distributed to everybody in about a week or so after today. So if there if there is nothing further, thank you again, everybody, for your participation today, and have a good day.